Let's talk a little bit about the attorney-client privilege. The attorney-client privilege happens between an attorney and a client, and the person who holds the privilege is the client. The client has a right to refuse to disclose or to prevent anyone else from disclosing communications with that client's attorney. The attorney-client privilege is one of the oldest privileges around involving confidential communication. Often people say that attorneys are the second oldest profession, and so our duty to keep the confidence of our clients has been around for a very long time. The reason for the attorney-client privilege is to encourage clients to make full and complete disclosures to their attorneys so that their attorneys can give them good advice and adequate representation. If you're lying to your attorney, you may not get the advice that you need. The requirements of the attorney-client privilege are that the privilege holder is the client, the other person that the communication is made with needs to be a licensed attorney, and that attorney needs to be acting as an attorney. So if your friend is an attorney and you're just chatting with them about something that happened in your backyard and it doesn't have anything to do with seeking legal advice, there's no privilege attached. The communication has to be for the purpose of getting legal advice. There are some exceptions to the attorney-client privilege that are important. One is if that you have a communication with an attorney and somebody else who is not an attorney and who is not a client is present, then the communication is not privileged and other people can find out about it. So this might happen if you bring somebody along to an appointment with an attorney and they're in the room while you're chatting with your attorney and they're not part of the world of people that is getting advice from this attorney, then those communications aren't privileged. Another exception to the attorney-client privilege is if the communication is in order to commit a crime. So if you have reached out to your attorney to seek legal advice about how to commit a murder, that's not going to be privileged. And the last exception to the attorney-client privilege is that it can be waived by the client. There are a variety of ways to waive it. A solid example is if the client discloses the information themselves to a third party, then the privilege is waived. The attorney-client privilege is really valuable in estate planning because what we're talking about with estate planning are really intimate things. It's about all of your stuff, all of your assets, and all of the people you love and know. I love that my clients know that they can speak to me and that I will hold their confidence so that they can be frank and really learn what they need to learn in order to protect themselves. If you'd like to discuss your life and legacy planning in a confidential environment, feel free to reach out to me. I'd be happy to chat.